Just an overview of what we're going to do today. What is a will substitute? An overview of the probate process and why will substitutes are important. Using bank accounts and brokerage accounts as will substitutes. Contract provisions effective at death. Real property transfers. Revocable living trusts. And the advantages and disadvantages of revocable living trusts. A will substitute is basically something that allows you to pass your assets at death or even during your life without probate. This can encompass anything that we have a beneficiary or a joint ownership. Now keep in mind that will substitutes may avoid probate, but that doesn't always mean that they're not taxable under the estate tax. The reason we want to do will substitutes is we want to avoid probate. So what's probate? Probate's the process that involves evaluating the assets, determining the types of administration you're going to need. Then there's a person who's designated or chooses to be in charge. They hire an attorney, file some papers with the court, get appointed by the court, and then they file an inventory after they've gone through everything that you've owned. And then they have to wait a minimum of, depending on the state, let's just say 90 days from the time that they put a notice in the newspaper to see who comes forward to make any claims. And then if all goes well, then they can distribute the estate and close it. I simplified it significantly. I've rarely seen a case that goes through without an issue. The shortest formal estate I've ever done, which is the process I just described to you, was 5 months from the time we submitted it to court. The longest ones, even when there's very little or no money in the estate, are still open years later because there's always some sort of issue to address. So the best plan is usually to just try to avoid that whole probate process. But whether a person has a will or doesn't have a will, if they own anything in their individual name, they're going to have to go through probate. Now that's a big misconception most people have, is they think if they have a will, they avoid probate. But that's not the case. If you have a will, you get to designate where your property goes, but you still have to go through the probate court to get there. The more work that needs to be done after your death, the more time it's going to take and the more costly it's going to be. Now, you also want to keep in mind that if you have assets in your own name and it's going to go through probate, well then if you have any beneficiaries who are under 18, in addition to probate, there's going to need to be some sort of court guardianship over that kid's money until they turn 18. And then when they're 18, they get that money, whether they're old enough and responsible enough to get it, doesn't matter, they're going to get it. That's why will substitutes are important, and that's why we're having this webinar today. Some types of will substitutes are bank accounts and brokerage accounts. A bank account or a brokerage account can be owned as joint with rights of survivorship, which means that 2 or more people can own the account and the survivor inherits the account. The thing about these accounts is that they work well as will substitutes, but the owners must keep in mind that each owner to own the whole account, which means that if an individual has a creditor, that creditor can seize the entire account. This is a common type of ownership where you have states where there's something not available called tenants by the entireties. So husbands and wives might own the property or the bank accounts or the brokerage accounts as joint tenants with rights of survivorship. Now let's just talk about the difference here. Tenants by the entireties, which I just mentioned, is only available to a married couple, so they can be the only owners on the account, and it's only available in states that have tenants by the entireties. So some states have it where it's only regarding real estate, some states have it for real estate and personal property. Florida, which is where we are, is actually the best state that you can have tenants by the entireties because you can own absolutely anything as tenants by the entireties. So what is it? It just basically means husband and wife own the asset, and then if one of their creditors gets a judgment against them, they cannot take the property if it's owned tenants by the entireties. So before we said that if it was owned as joint with rights of survivorship, either creditor can take it, but with tenants by the entireties, they can't. There's also something called payable on death accounts, which is common in bank accounts. And that just means that you own your account until you die, but you have a beneficiary listed who all they need to do when you pass away is present a death certificate and get the money in the account. So during your life, the beneficiary has no entitlement, and you can always change the beneficiary as long as you're competent. Now there's a twin provision when you've got a brokerage account, which is called a transfer on death, which is basically the same thing as the payable on death. Now, I want you to keep in mind that a beneficiary under either one of these types of accounts can be a human being or it can actually be a trust. Now, I want to distinguish between a power of attorney account. So a power of attorney account is not a will substitute because the power of attorney expires at the person's death. So this type of account would go through probate unless you also have a payable on death beneficiary attached to the account. So it's important if you're opening a power of attorney account to make sure that you have a payable on death beneficiary attached to it. And also the power of attorney account is not usable after the person dies because that power of attorney expired. So we distinguish that with the joint account with rights of survivorship and the tenants by the entireties account, which pass directly at death. And lastly, you can set up an account for your children where you're not the owner, you're just a custodian. It's called an UTMA account, a Uniform Transfers to Minors account, where your child's Social Security is used for the account, and therefore they are the owners and you are not, so it wouldn't be probated. Now let's talk about another type of will substitute, contract provisions. So we just talked about payable on death and transfers on death. Those are actually contract provisions as well because there's a contract with the bank that when you open your account that says, if something should happen to me, the bank will pay the third party, the beneficiary, at my death. So this is also true with some other types of assets. First off, you've got life insurance. So with life insurance, you can buy a life insurance policy and it pays a death benefit at your death. It's imperative that the named beneficiaries be living at the time of your death. Otherwise, that's going to have to go through probate too. So the way to counteract that is to make sure you have some sort of contingent beneficiary or secondary beneficiary. Now, policies that name a beneficiary who's died, as I said, is going to go through probate. So again, very important to always keep up with the policy and make sure you've got current beneficiaries. There's a couple of types of policies. Number one, you've got a term policy. There you pay a premium for a period of time with a guaranteed death benefit. But after that term, the premium usually increases significantly, so term policies are not usually kept into old age. They also have no cash value, but again, their premiums are probably a lot lower than whole life policies. So they're good if you need life insurance to cover a short period of time. You've also got a whole life policy, which builds up cash value as you pay the premiums into it, and you can borrow against that. So it's actually a good savings tool. The premiums are usually the same for life, but they're usually much more expensive than a term policy. But since they do build up cash value, they do have additional value to you when you pay in the premiums. You're not just throwing your money like a term policy. Now the other option is a universal life policy, which is kind of a hybrid of the two. And with that, it's usually a solid continuous premium, but the cash value goes up and down depending on how the market does. So you can build some cash value in there, or you can end up with no cash value. It just depends on the volatility of the market. And there's also other ways to handle ownership of life insurance to maximize its usefulness and keep it outside the taxable estate. For instance, an irrevocable life insurance trust is kind of beyond the scope of today's talk. We also have annuities, and those are financial products sold by financial institutions. And the idea behind those is that they grow and they pay out a steady stream of income to you or some other individual at a later point. Now, these are great for retirement because you can get your income flow, which substitutes for what you're losing from your employment, from your salary. And basically the idea is if you can replace that cash flow, then you're not going to be in a poor position after you retire. Some annuities have death benefits, which is what we're talking about in terms of will substitutes. Some don't. Some annuities pay a fixed amount. Some pay a fixed percentage. It just depends. Other types of will substitutes in this vein are qualified retirement plans, which can also be excellent asset protection tools depending on what state you're living in. These plans have to meet the requirements of the IRS in order to receive their tax benefits. They have to be exclusively used for the benefit of employees and their beneficiaries, and they can be substitutes for will substitutes as long as your beneficiary is living. Now, you have some flexibility with how you leave these plans. For instance, an IRA. IRAs can be used as a stretch IRA, where you can actually extend payments to the life of your grandchildren. If that's something you're interested in, you should really discuss that with your financial planner. You can also use trusts with that IRA to make that stretch happen. And why you would want to do that is, let's say your children would have been your IRA beneficiaries and they are in a high tax bracket. Well, if they pull money out of your IRA, they're going to be paying tax on that. So if you can stretch it out into the life of your grandchildren, then it could be tax savings later on, and your children don't need to pay taxes on it. There are basically two types of qualified plans. There are defined benefit plans and defined contribution plans. Some examples of a defined contribution plan are 401ks, money purchase pension plans, and profit sharing plans. 401k is a retirement savings plan sponsored by your employer. It lets your workers save and invest a piece of their paycheck before the taxes are taken out, and taxes aren't paid until you withdraw the money. Now, with a 401k, you can control how your money is invested. Plans offer different types of investments. It just depends on how you're vested in that one. You can help you save for retirement, and if there's anything left over at your death, then it can pass to your beneficiaries, again, without probate. A 403B plan, I'm not going to spend much time on that. It's a special type of tax-sheltered annuity. It is only available for certain types of employees, really for certain types of employees of employers, like public schools, certain tax-exempt organizations, maybe some ministers. There's different types of accounts that can be part of the plan. There's no tax on the contribution until you start withdrawals, and depending on whether you use a Roth IRA in there, the contributions can either be excluded from your income or potentially deductible. But again, it's only limited to certain types of employees who can invest in that. Next, we're going to talk about real property, which is land, houses, buildings, things of that nature. How can you pass that without putting it through your will? So the three most common ways are through a trust, tenants by the entireties, joint tenants with rights of survivorship, and of course state, which we'll go into. Tenants by the entireties, we spoke about earlier. It's only available for a married couple, and basically what happens is if it's owned tenants by the entireties, if one of the couple dies, the other inherits the property. Very simple, but keep in mind when the second one dies, if they didn't do anything, it's an individual asset that might potentially go through probate. Joint tenants with rights of survivorship works the same as tenants by the entireties, except you can have more than two owners, and they all own an equal interest in the property, and the last one surviving inherits the whole property. And then you've got life estate, where you can actually have an interest in a property as the right to live there for the rest of your life. You pay all the expenses, and then when you die, the property is already owned by others who are called vested remainders, and it passes again without probate because the remainder interests already own the property and we're just waiting for you to die in order to inherit. Two of the biggest advantages of joint tenants with rights of survivorship is that it's very hard to sell the property without the consent of the other joint tenant. And since, again, we mentioned this earlier, each one is considered to own the whole property, so one of their creditors can actually get at the entire property. Now let's talk about trusts. This is probably the single most popular will substitute nowadays. You can create the trust by separating out legal and equitable title to any type of property. That means I can take property that I own, create a trust, which is basically just a document, and I transfer the property to the trustee of the trust, who then holds legal title for the benefit of the beneficiary or the equitable owner. There's essentially two categories of trusts. You've got revocable and irrevocable. A revocable trust is one where the creator of the trust, also known as grantor or settlor, can do anything he wants with the trust, whether it's to change it or terminate it. Whereas an irrevocable trust is one where the grantor usually gives up ownership and control of the property. So once they've created it, they cannot change it. Funding a trust is a great will substitute, but an unfunded trust is not an effective will substitute. And this is a big thing that I see all the time. Many people have come to me and have created these revocable living trusts, but they've put nothing into it. Well, if you don't put anything into it, then your assets still have to go through probate in the trust, and hopefully you've put some complex provisions into the trust as to how things will be distributed. So it'll get where you want it to go, ultimately in the trust, but it has to get through probate in order to get there. Completely unavoidable. That was not the purpose behind it. The unfunded irrevocable trust is also an absolute complete waste. They're usually more expensive to set up, so if you didn't fund the irrevocable trust, you've really wasted your money. Now, one of the main purposes of the irrevocable trust is to transfer your assets out of the reach of creditors and potentially to get some tax benefits. So once again, if you fail to fund it, total waste. Now, what are some of the advantages and disadvantages of creating, or we'll talk right now about the revocable trust. The main advantage is what we're talking about today. It's a will substitute and avoids probate. You can also amend the trust wherever you see fit. You retain complete control over the trust if you want, because you can be both trustee and beneficiary of your revocable trust. And finally, when you die, the trust and its provisions can remain private because they don't have to go through the court. As for the disadvantages, it can be costly to set up, and there can be some ongoing maintenance costs depending on how you invest the funds, or if you decide not to be your own trustee, which is unusual, but people do it. You can also pay some taxes if you don't set things up properly. And finally, there might be some cost to transferring assets into trusts, like if you have real property and you need to do a deed in order to get it in there. But all in all, best will substitute that you can do because it has the greatest flexibility.